Hello, my name is Meg Gailey. Tribunals are created to resolve disputes about very different and specific topics, so every tribunal follows its own set of rules and procedures. The first thing you should do is look on your tribunal's website, if there is one, to find out what steps will be followed in the dispute resolution process. For example, WorkSafe BC has its own set of rules for resolving disputes, and they are different from those that the Employment Standards Branch uses. Most tribunals have important information on their websites, like legislation and the procedural rules and policies they follow. It is very important to understand the rules that apply to your case. For example, there are time limits for filing documents, and failing to meet a deadline may prevent you from proceeding with your case or from introducing documents at a hearing. Some tribunal websites provide a database of previous decisions that it has made. You can read about cases that are similar to yours and find out what decision the tribunal reached. That information will help you understand the issues in your own case and may help you resolve the dispute with the other party. Tribunals are set up to be less formal than courts, and the procedures are usually simple enough to follow on your own. It's always a good idea to ask the tribunal what kind of help they can give you. Some tribunals, like the Workers' Compensation Appeal Tribunal, provide free assistance to workers and employers who are involved in a dispute. If you need more help, think about talking to a lawyer who can explain the issues to you or represent you at a hearing. All tribunals will try to make a decision about your case as quickly as possible. First, the tribunal will do a preliminary review of your case to make sure that you made your complaint to the correct tribunal within the proper time limit. After that, the tribunal sometimes tries to resolve your case so that a hearing will not be necessary. These ways of resolving disputes without a full hearing are called alternate dispute resolution. An adjudicator may get involved in managing your case and arrange a telephone conference call with you and the other party to make sure that everyone understands the issues that are in dispute. Sometimes the case is resolved as soon as the parties have an opportunity to talk to each other about the problem. A settlement conference or a mediation session may be scheduled to help you resolve the disputes as soon as possible. The goal of mediation is to resolve the matter in a way that is acceptable to both parties. The mediator is a neutral person, often a tribunal member, who helps the parties reach a mutually acceptable solution. This approach gives you more control over the outcome because a decision will not be imposed on you. But if you cannot reach an agreement with the other party, your case will be adjudicated in some sort of hearing process. A settlement conference is similar to a mediation session. A tribunal member will meet with both parties and take an active role in the discussion. He or she will tell you what the result might be if you have a tribunal hearing. This type of opinion is non-binding, which means that you do not have to accept it. Settlement conferences are used when the tribunal must ensure that your agreement follows the legislation that applies to your case, such as issues before the Property Assessment Appeal Board. If you cannot resolve the dispute in the early stages, an adjudicator may hold a hearing and make a decision. Not all tribunal hearings are done in person. Many hearings are done over the telephone or by presenting written submissions. Sometimes the tribunal will arrange for the hearing to be done by video conference, so you do not have to travel a long distance to attend the hearing in person. The tribunal will usually tell you what kind of hearing you will have, but sometimes you can choose. So, after you've looked at the tribunal's website, you should start gathering evidence that you will need to prove your case. You may have to submit documents to the adjudicator or exchange them with the other party. The success of your case depends on the evidence that you provide to support your position. The best evidence is direct, relevant, and original documents, statements, or other information that supports the facts of your case. The adjudicator will give more weight to relevant evidence that is seen to be reliable. Collect important documents like contracts, letters, receipts, financial statements, canceled checks, and anything else that you think is important to your case. It is always better to bring original documents to the hearing, but if you can't get the original, bring a clear, readable photocopy. You should also think about whether you want to bring witnesses to the hearing. The best witness is someone who actually witnessed an event. For example, if your landlord says you did not pay your rent, and your friend was with you when you delivered the rent to the landlord, you will want your friend to tell the adjudicator about this. Your witness can come to the hearing in person, or if that isn't possible, you can bring a sworn statement, like an affidavit, from the witness. In some cases, you may want to have an expert witness provide a report or give opinion evidence at the hearing. An expert is someone qualified with special knowledge, skill, training, and experience, like an engineer or a doctor. Special rules apply if you plan to bring an expert witness to the hearing or submit an expert's report, so make sure that you read the tribunal's rules when you are preparing your case. You want to make the best possible presentation to the adjudicator. This means that you must start preparing for the hearing well ahead of time and organize your material. Putting your documents in a binder with tabs is an easy way to organize your material. Find out how many copies you must submit to the adjudicator. The best way to prepare for a hearing is to watch one. This will help you understand how hearings are conducted and help you prepare for your own hearing. Check with the tribunal to find out if hearings are open to the public and when they are scheduled. If you cannot attend a hearing, think about talking to a lawyer or someone who has attended a hearing so you know what to expect. And find out if there are self-help materials that will help you prepare for your case. When you go to the hearing, there are 4 things that you will need to tell the adjudicator, whether your case will be heard in person, by telephone, or by written submissions. First, tell the adjudicator the relevant facts they need to know about your case. Second, present these facts in a clear and simple manner. Third, provide material to support your case. And fourth, explain how the law supports your case.